This presentation is the introduction to Katie Beckett deeming waiver, though we will be speaking quite a bit about the Katie Beckett appeals process and what to do if you are denied. First, a little bit about myself. My name's DJ Jeyaram. I am an attorney here in Georgia. I've got 20 years of practice experience. I was formerly the Deputy Director of Legal Services for the Georgia Department of Community Health, which runs the Katie Beckett program. I was also an administrative law judge for 4 years, and in that role I would preside over Katie Beckett appeals and IEP appeals and other types of special needs cases. My firm right now, Jeyaram & Associates, we specialize in healthcare regulatory matters, Katie Beckett and now comp waivers, and special needs trusts and estate planning. What we're going to talk about today is we're going to do a little bit of an overview of Katie Beckett. There's some misinformation out there, and I get a lot of questions, not just what is Katie Beckett, but kind of what is the package of benefits associated with Katie Beckett. The roadblocks we see towards Katie Beckett approval, which of course leads to denials, and we'll go through those top 5 reasons for denials. And then if you are denied, we'll talk about the Katie Beckett appeals process. The reason I got into this area of the law is the light of my life, which is my 7-year-old son, Kai. Kai has a diagnosis of autism and Williams syndrome, and we are actually on the Katie Beckett program, so not only do I see Katie Beckett from an attorney standpoint, but I see it from the parent standpoint. So what is Katie Beckett? One of the big misconceptions out there, or one of the questions I get from parents is some kind of question along the lines of, is that a Katie Beckett benefit? Well, there really is no Katie Beckett benefit. The way to view Katie Beckett is it's a doorway into Medicaid benefits. Just like any other type of doorway, whether it be disability or low income eligibility or SSI eligibility, Katie Beckett is just another form of eligibility. So there is no Katie Beckett package of services as much as Katie Beckett's a doorway into all Medicaid services. So to qualify for Katie Beckett, you have to meet a certain level of care. Now there are 3 options for that. One is the hospital level of care. That is when your child requires an actual inpatient hospitalization level of care. We don't see a lot of denials around that level because those children's needs are so extensive. The second is the nursing facility level of care. Those are for the children who do have extensive needs, may not have an intellectual or developmental disability, but do need skilled services on a regular basis. And by skilled services, what we mean are skilled nursing services, but it can also be services from an occupational therapist, a physical therapist, or a speech therapist, or any other skilled licensed individual. The services have to be received by an individual a minimum of 5 days a week. The last level of care is the intermediate facility level of care. That's called an ICFID, Intermediate Care Facility for Intellectual Disabilities. Those are the children who do have a developmental disability or an intellectual disability or something or a condition that mimics the challenges of those with an intellectual or cognitive disability. And we'll get into that a little bit later. One of the big reasons for denial that I'm sure a lot of you are seeing out there under the ICFID is the requirement the department has that a child be receiving services 5 days a week. There are a lot of questions out there about, well, is it 5 days a week or is it 5 sessions a week? And we'll get into that a little bit later when we talk about the roadblocks. As I mentioned, Katie Beckett is one of those, is a doorway to Medicaid services. What services are included? Well, for children under the age of 18, under federal law, children are eligible to receive from Medicaid anything that is deemed medically necessary. So occasionally we hear parents ask questions saying, well, Medicaid won't cover that. Well, federal law says a state Medicaid agency can't say for a child, we won't cover that. If it's medically necessary, they have to cover it under the EPSDT law. So if you ever run into one of your child's healthcare providers, or even someone from the department, and they say something along the lines of Medicaid won't cover that, the real question is it medically necessary for your child? And if it is medically necessary, it has to be covered. If it's not medically necessary, obviously it does not. Katie Beckett's incredibly useful. Your primary private insurance. It'll also cover many things that private insurance may not cover. An example from my own life is our private insurance will not cover compounding of certain medications for my child because he has trouble, difficulty swallowing a pill. We want it in liquid form. Well, Medicaid's covered that for him, which has been incredibly useful for us. Okay. So what I have up here is an actual printout of the ICFID level of care from the Katie Beckett manual. And this is probably one of the most important slides in the entire presentation. This slide and its nursing facility slide are really, this is kind of the end-all and be-all of Katie Beckett eligibility and Katie Beckett denials. This is the chart that you have to meet. If you meet this chart, you will qualify for Katie Beckett, assuming you meet the financial eligibility requirements. And we'll go into some detail a little later about how you use this chart as an outline on how to write an appeal letter, whether a first level appeal letter or a second level appeal in front of an administrative law judge. You would use this structure to present your case to a judge. So let's start with the application process. We all know, anyone who's applied, it's extensive, it's exhausting. It takes a very long time to complete. You have to get a lot of documents together. The Katie Beckett manual itself is 42 pages long, and I believe that does not include the exhibits. So it is a long, long process, but as I mentioned before, the benefits associated with getting onto the program are immense, and especially for children who might have more expensive medical needs, things like hospitalizations. Having Katie Beckett as a primary or secondary insurance, it could be incredibly valuable and really financially life-saving for some families. Point being, it's worth it. Take the time, go through it. There are advocates out there that do help families with this, and they are really pretty affordable. You can always contact parent to parent to get a list of advocates who can help you with the application process. It is stressful. I won't kid you, but again, my best advice is stick with it. One of the things we see happen quite a bit with families is they will give up. They will say, well, look, who has the time? We know as parents and as the parents of children with some special needs, we're busy. There's not enough hours in the day to do all we need to do. But it is worth it just to kind of push through a little bit to make sure you can get a good Katie Beckett application submitted. This is just a short list of some of the things that you're going to need to submit with your Katie Beckett application. Proof that your child does not qualify for Social Security. If they do qualify for Social Security, they will be eligible for Medicaid through that category of eligibility. So that's why you need proof that your child does not qualify. You'll need certain forms completed by your doctor. It's called a DMA-6. I think it might be a DMA-7 now. And your physician will have to fill that out along with recommendations for a level of care. You'll need copies of your child's medical history. You'll need 90 days of therapy notes and plans of care. Now, if you're initially applying and you don't have 90 days of notes, that's okay. In your application letter, you should note that this is an initial application, that you've either exhausted your private therapy or don't have coverage for private therapy. You explain that to the department, and they usually look at that and understand as an initial application, you might not always have coverage for those therapies. If your child has an IEP, they'll want a copy of that. Level of care statement, where your physician checks off which level of care that they feel your child will qualify under. If you think your child will qualify under more than one level of care, and so if you think they would qualify under ICFID and nursing facility level of care, check both. It doesn't hurt to see if you qualify under either of those. Cost effectiveness form is a little bit self-explanatory. A psych eval, it's got to be completed within the last 3 years and include an IQ score for your child. And of course, your basic Medicaid application. We hear a lot from our clients, from the parents, about frustrations through the application process. Things like, we've applied 3 or 4 times. It's confusing. We're not sure why we're being denied. I'll be honest with you, the denials that the department issues are confusing, and it's kind of hard to figure out exactly why you're being denied. If you do receive a denial letter, contact parent to parent, contact my law firm. We can help you figure out exactly why you're being denied and what next steps you should take. Here are some of the major roadblocks that we are seeing and where parents are getting denied. Number one is missing information. That's not fatal by any means. What the department will generally do if you're missing a required page, or, for example, you forgot to include your IEP, they'll send out something called a technical denial. And now, technical denial will literally say, and what you have in the slide here is a picture of a technical denial. And it'll check off the box saying, hey, we didn't get this piece of information. Please send it to us. So it's called a denial, but all it's really saying is, if it's a technical denial, all it's really saying is that you're not getting or you haven't submitted all the required paperwork. The second thing we hear quite often are that the application was not received or lost. When we do hear this from parents, they are at their wits' end because they have probably spent dozens and dozens of hours putting together the application and gathering all those documents. What you need to do in a situation like that is, one, make sure you always keep a full copy of whatever you submit to the department, whether it is an initial application or a renewal application. Always keep a full copy of what you send in. The second point on lost applications, make sure you send everything to the department certified mail. You want to make sure that you can prove it was received by the department, and that becomes incredibly important to show that you've met deadlines. that you've put in your reapplication or your application within any deadline. If you are outside of a deadline, you probably do have to start the process over, which everybody wants to avoid. So remember, keep a complete copy and also send everything certified mail. And of course, the ultimate roadblock is if your application or reapplication is denied. We are seeing, and we have on this slide, that approval on initial submissions, approval on initial submission is rare. We have seen a significant uptick in denials over the last few years. We constantly asked by parents what has changed in the Katie Beckett laws, regulations, or policies that's causing this uptick in denials. And really, from our research, we are not seeing any changes in the law, the regulations, or even the Katie Beckett policies that are causing these denials. We believe the denials are more based on the Department of Community Health's interpretation of the policies. Now, whether their interpretation originally, when more people were getting approved, was correct, and now they're incorrect, or vice versa, they were incorrect then and correct now, hasn't been established in court yet. It's probably just going to be a matter of time, but there's no clear answer to that. We do believe, from a legal perspective, that if the laws and the regulations have not changed, that the department's interpretation cannot change, but it has, and that's the reason we're getting more denials. The top 5 reasons for denials, what we're seeing are IEP sessions, therapy sessions without notes or lack of documentation. This is by far the biggest one, and even as recently as this morning, we're getting different information from people who have been in contact with the department. For many years, the department would accept IEP therapy sessions towards meeting the 5-day per week requirement in the ICFID level of care and the nursing facility level of care. What we are now seeing is for those sessions to count towards the Medicaid requirement, you need to have a physician's note saying that your educational IEP therapy sessions are medically necessary. The second thing you need daily, according to the department, you need daily notes for each therapy session received through the school system that meets the Medicaid standards for record keeping for the department to consider those sessions. We've seen several denials, really even in the last couple months, on that basis. But as recently as this morning, we've heard from a parent who said they spoke with the department, and that's no longer the case, that the department will accept IEP sessions. We have not seen that, and that's, of course, rumor and hearsay. Our advice to you is to, as best you can, if you can get your school system to provide documentation of what happened in each therapy session and what was being worked towards, date it, and have the therapist sign it. That will go a long way to getting approval. The IEP services pursuant to a plan of care, that's another problem we're having. Again, that has to do with the department saying any kind of educational services that you're receiving, any kind of educational therapy services, also have to be medically necessary for them to consider them to meet the Katie Beckett level of care. To that end, what the department wants to see is whatever you're receiving in school somehow being reflected in your private therapy plan of care. So it's not enough that those services just be in the IEP. That's not sufficient because an IEP does not constitute a medical plan of care. What your private therapists create for you in terms of a plan of care, the department wants to see the IEP services somehow reflected in that plan of care. The fourth reason is the letter of medical necessity signed by the department does not support the level of care that's being requested. So for example, let's just use ICFID. If you need to be getting the 5 therapies a week, but the letter of medical necessity says 4 times a week, well, that's going to be an automatic denial. If your physician can't say 5 days of therapy is medically necessary, you're not going to get approved. So what we advise clients to do is, make sure that after you get those letters back from your pediatrician's office, you compare them to that chart, the chart I showed you in a earlier slide on ICFID or nursing facility if you're applying under that level of care, and make sure that everything that needs to be in that letter of medical necessity is in there as laid out in the chart. I'm sorry, my numbers are off here. I went 1, 2, 3, 4, 1. But number 5 is the services being received, and this is mostly under the nursing facility level of care. The services being received are not complex enough, which means that, as I mentioned earlier, under the nursing facility level of care, the services being received by the child have to be complex enough that they can only be provided by skilled staff being a nurse or a therapist or really anyone else who is licensed in the state of Georgia, and essentially cannot be performed by the family. Now, federal law is a little more lenient, and there have been cases on this issue. And what federal law says is just because a parent can be taught to provide a service does not render that service unskilled. So in other words, and we all know this, we do things for our children sometimes that normally a nurse would be doing, but we do it because we have to do it. Otherwise it won't get done. The nurse may not be there. Well, what federal law says is, well, just because mom and dad do it sometimes doesn't mean it's not skilled. And if it's skilled, if it's a skilled service, it does qualify towards that nursing facility level of care. So I just wanted to spend a little bit of time running through kind of what Katie Beckett was and what we're seeing in the application process, but I really did want to spend some time on the appeals aspect, what to do if you are denied. There are 2 stages to the Katie Beckett appeals process. Number 1 is if you're denied, you'll receive in the letter either something called a technical denial, which I noted before. You're just missing documentation that the department needs to see. And number 2, you could receive something called an initial denial. Now, the appeal from an initial denial is to provide the department with more information, whether it's documentation from your caregivers, from your physicians, or even just from the parents. Provide the department additional information to say, look, based on why you're denying us, we feel you're wrong because. And it's incredibly important to make sure that you meet the deadlines that are laid out in the letter. If you miss that deadline, the denial becomes final and you have to start the process over again. So again, make sure you meet all deadlines. For the initial denial, it's generally 30 days from the date of the letter. Now, let's be clear on that. It's the date on the letter, not the date you receive it. So if it takes the department or the post office a certain number of days beyond the date of the letter, let's say it's a week later until it gets in your hands, well, they don't make allowances for that. You have to make sure that you meet the deadline 30 days from the date of the letter. Now, if you go through that first process, the request for administrative review, and you provide additional information to the department, and you still get denied, what you'll get in the mail is something called a final denial. And it will have your next step in the appeals process laid out, which is to request an administrative hearing in front of an administrative law judge and have them decide your case on whether you meet the criteria. As I mentioned, make sure you meet all deadlines. Actually, I'm going to go back for 1 second. When you are writing the request for administrative review, go back to the slide, and you've all seen it at some point, that chart that I had in an earlier slide. And let me go back to it. This chart. What I tell parents to do is structure their request for administrative review the same way this chart is structured. So if it says you have to meet all items in the first column, literally say the services literally say we meet number 1 because, we meet number 2 because. And just structuring your paragraphs like that hopefully makes it easier for the department's reviewers to follow what your arguments are, what your points are in relation to this chart, because they're looking at this chart when they're reviewing your paperwork. So it makes sense to structure your letter the same way the chart is structured. One of the things that's important to remember is you know your child better than anybody. You certainly know that your child better than the department. So if there are things you feel they meet that the department is saying they don't, explain why from a parent's point of view. Why? For example, if you look at this ICFID chart on this slide and you go to the far right column in number 4, and they're saying, well, look, we're not seeing challenges in self-care skills such as feeding, toileting, dressing, and bathing. Well, you certainly have your psych eval to show limitations in that area if there are. But sometimes the numbers don't tell the entire story, and to elucidating some of what the numbers stand for, where your challenges are, sometimes help paint a picture. If you had not submitted a picture of your child with your initial application, definitely submit it with your appeal letter. It always helps for the department to have the picture of the actual child in front of them so that it's not just a bunch of papers and medical jargon. They associate a real face, a real live child to this request for services. We always find that that's helpful. So back to the Katie Beckett appeals. Hopefully after the initial level of appeal, you would have been approved, and that would be the end of it. But if you don't get approved and you get a final denial and you have to go to an administrative hearing, there are several tricks that you need. You can always hire an attorney to represent you at that stage. The department will have an attorney. It's not always necessary, depending on why you're being denied, why the department is saying you're being denied. If that's something that you as a parent feel comfortable speaking in front of the judge, you can do this yourself. Now, there is the burden of one of the key issues before going in front of the judge is who has the burden of proof, who has to prove their case. Well, in an initial application denial, the burden is on the family. They have to show that they meet all the qualifications to get into the Katie Beckett waiver. Well, again, go back to that chart. If you're going to structure your presentation to the judge, that's how you structure it. You structure it, we meet number one because, we meet number two because. Again, it's a very formalistic way to present, but it's the kind of thing a judge can grasp easily because they're sitting there with that chart in front of them, and they're going down the list as you're explaining why you meet number one and why you meet number two. Now, if it is a renewal application and you get denied, the burden of proof is on the department to show that you don't qualify. Whichever party has the burden of proof, they go first. They present their evidence to the judge first. As we said, the administrative hearing is in front of a judge. It's in a courtroom, generally in downtown Atlanta. It is a closed hearing since you're going to be talking about medical issues, so the department will be there with its witnesses and you will be there with your witnesses. The rules of evidence do apply in these hearings, but the judge does have the discretion to allow things in contrary to the rules of evidence, and many times when a family is not represented, they will do that. The process in which the hearing goes, both parties will have the right to make an opening statement. The opening statement, whichever party has the burden of proof will go first and give their opening statement. The opening statement, that's a roadmap to judge, this is what we're going to show you with our evidence. This is what our witnesses are going to say. You will have to call witnesses. It's important, certainly a family member will be a witness since they know their child better than anybody. It is incredibly useful for the families to have a medical witness, whether it's the child's pediatrician or specialist. The kind of weight that a medical professional brings to the table, especially if the denial is based on a medical issue, is incredible. Certainly, if it's a medical issue, the department will have its own medical witness, and it's very hard for a family to prevail on a medical issue when the department has a doctor saying something is not medically necessary, or that the family doesn't meet a certain criteria. If the family does not have their own doctor saying that's not correct. When the witnesses are called, when you call your witnesses, you will have to ask them direct examination questions. That's generally who, what, when, where, why. I'm sure you've all seen legal TV shows when an attorney will jump up from the table and say, objection, leading the witness. Well, that is a real objection, and when you are questioning your own witnesses, you generally cannot lead them. If you ask who, what, when, where, why, you won't be leading them. You will have to cross-examine the department's witnesses. So if the department calls its witnesses, they will ask their witnesses the who, what, when, where, why, and then you can ask questions on cross-examination of those witnesses. Very effective cross-examination questions include what that medical witness knows about your child. Certainly, on almost every case, the department's medical witness will never have met the child. They would have never examined the child. The sum total of their knowledge of your child will be in the documentation. Now, when a judge is weighing that against your physician, who has been your child's physician since birth or for 5 years and has examined them several times and reviewed all medical records and has seen the challenges that the child and the family have, well, the judge is really going to weigh the testimony of those two experts and almost always gives a little bit more weight to a expert physician who has actually seen the child. And finally, the hearings wrap up when both parties give a closing statement. Again, the party with the burden will go first. And the closing statement is basically telling the judge, look, this is what our witnesses said, this is what their witnesses said, which was incorrect, this is what the documentation shows, and this is why we qualify. What needs to be proven at the hearing? In other words, what questions do you ask on direct or even on cross? And that's where you go back to your chart. Go back to your chart, have that in front of you at the hearing with a red marker, and go line by line. If the burden of proof is on you, you go through every element on that chart, either asking your witnesses, which may include yourself, why does my child meet this? Why does my child meet this? And you work through the list. It can be a little time consuming, especially if the burden's on you, but that's what we advise parents to do. Now, if the burden's on the department, make sure that the department goes line by line through the list on why you don't qualify. Now, when you look at the lists, there could be 20 different things there. Well, that's great. Well, if the department only points to 2 of the 20 and says, look, you don't meet this one and this one, well, that's all you have to address on your counter case to them. Now, again, this is when the burden of proof is on the department. They go in, and if they're just saying, look, it's just these 2 things you don't meet, when you put your witnesses up there, you just have to address those 2 things. So when the department's going through the different lists, check off the boxes, check them off one by one, and say, okay, well, the department put in some evidence on number 1 and number 2, but nothing else. Well, now your case has just gotten simpler. You only have to present evidence on number 1 and number 2. Specifically, what will happen at the hearing, the department almost always calls their Katie Beckett program specialist, who will talk about Katie Beckett program in general and how the applications are reviewed. And they will call either a GMCF, Georgia Medical Care Foundation nurse, or a physician who reviewed the paperwork and ultimately found that your child does not qualify. As I mentioned, if the parents can get a medical witness to testify on their behalf, that is incredible. And quite frankly, I feel necessary on the if it's a medical issue. Case law does give deference to the parents and the parents' caregivers, again, because of knowledge of the child. That case law is available. It's generally federal case law, but it will be applicable in your hearing. One of the things we found to be very effective cross-examination questions of the department's witnesses is ask how many applications they review a day. They review a lot. There are a lot of applications. What might take you 20 hours to pull together, they might only take 10 minutes in reviewing. Do the math with them. Go through and say, well, if you're working in 5-hour day and reviewing applications, and you review 100 applications in 5 hours, how many minutes is that per application? And I think it's very telling to the judges that, look, your knowledge of your child and your medical professional's knowledge of your child, which is gained over years and many, many hours, is being stacked up against somebody who not only knows the child from a stack of paper, but a stack of paper they probably only spent 10 or 15 minutes looking at. So it is one of those very powerful cross-examination questions that really drives home to the judge, look, we know what we're talking about more so than the other side. One of the questions we get quite a bit from families is, look, we don't know what the department's position is going to be. We don't know who they're going to bring. We don't know what documentation they're going to present. Some of the department's attorneys will give you all of that material ahead of time without you having to ask for it. Other attorneys, if they haven't given you what you want to see, the Office of State Administrative Hearings, which is where these hearings are held, has a rule, and it's Rule 19, I have it here on the slide, that you can subpoena documents or people to testify. And under that subpoena, they have to show up at the hearing with the documents, or that person has to show up at the hearing. Now, there are requirements. It has to be served by certified mail at least 5 days before the hearing. But this is a very effective way to get material that you want to look at that the department may not be willing to give you. A form subpoena is available at the Office of State Advice. So all you have to do is Google it, Office of State Administrative Hearings, or even OSAH, O-S-A-H, Georgia, and that'll take you to the main page. And there will be a link for form documents, and you can pull a subpoena form off the website. Another very effective way to find out is essentially what the department's case is. After your conversations with the department's attorneys and after looking at all the documents, if you still have no idea really why you're being denied, you can always email the court and request a pre-hearing conference with the administrative law judge. Now, if you email the court, make sure you email the department at the same time. You carbon copy them on that. During that call, if the judge grants it, which many times they do, you'll have a phone call with the judge and the department's attorney. You can just say, Judge, look, I really don't understand the department's case or why we're being denied. And, you know, the judge can help in regard to ordering the department to explain in, frankly, plain English why you're being denied. You can ask the judge to issue a pre-hearing order. What that order does is it'll say, look, we want both parties to exchange lists of who's going to testify and what documents they're going to use. That way, before you go into the hearing, you can be prepared. How to request the hearing, this should all be laid out in the final denial letter. The department must receive your request for hearing, and again, it's received. That's not put in the mailbox. That's be in the department's hand within 30 days from when the decision was received by the member. The final denial letters are a little different than the initial denial letters on the deadline when the deadlines start running. So make sure you read your document carefully. The request for hearing has to be in writing, and this is very important. A copy of the denial letter issued by the department has to be attached to the request for hearing. If it is not attached, the department will reject that request for hearing, and then you become in danger of missing deadlines. In your request for hearing, they generally want to know why you feel the department's decision is incorrect and what you want the department's decision to be. Obviously, you want the decision to be approval of your application or reapplication. The evidence onto why the department's decision is incorrect can frankly be as simple as we feel we meet the level of care. So don't worry about that too much, but you do want to put in a line or two covering those issues. And again, all of this should be laid out in the final denial letter. One of the most common questions we get from families is in a renewal, can the parents continue to receive benefits through the appeals process? The answer is yes, they can. Federal law does require that during the appeals process, the department allow parents to keep their benefits. Now, under those laws, though, if you ultimately lose at hearing, the department does have the right to go back and charge you for whatever they paid in the way of benefits for your child during that appeals period. Now, I have not seen that happen. That doesn't mean it does not happen. But in 20 years of doing this, I've not seen the department go back for that money. They may someday, and they certainly have the legal right to do that, so I don't want to advise you either way on whether to keep your benefits going during the appeals process. But if you feel that your case is strong, just know you have that option. And to the best of my knowledge, the department has not gone back to recoup those monies from families. We are kind of coming up on our deadline here. I know I've run through a lot of information at a high level and wanted to see if anybody had any questions.
Yes, a question is there is there a certain amount of time that you can appeal a denial?
If the question is, you certainly have those deadlines in which to appeal the denial, but ultimately if you're denied and at the end of the day the denial stands, there is no waiting period to reapply. You can turn around and reapply immediately.
Okay, so you can't appeal that same denial. Like you have to go back and reapply.
If the final denial stands and it becomes final, so you either lose your hearing or decide not to appeal, you can turn around and reapply again, and you always have your appeal rights associated with every application or reapplication, no matter how many you do.
Okay, currently I don't see anyone that has any questions.
Okay, this last slide has all of my contact information if you have any further questions. It's been my pleasure to speak to you about Katie Beckett and Katie Beckett Appeals. Parent to Parent of Georgia has asked me to let you know that you can contact them for additional assistance, information, and resources you and your family need. You can go to their website, which is www.p2pga.org. That's www.p2pga.org, or call them at 1-800-229-2038. If you have any questions regarding the content of my presentation, please don't hesitate to contact me directly via email, and my email address is up on the screen. If you would like to watch this webinar again or share it with a friend, will be able to have access to it in the future on the Parent to Parent website under archived webinars. Thank you again for attending my presentation.